President, I'm pleased to rise today and speak in support of the Youth Justice Bill. It is an exceptionally significant piece of legislative reform that's been brought before the Parliament today, far from some of the denigration of the process that previous speakers have made. This is the culmination of many years of work that a lot of dedicated public servants, ministers, experts have put into tackling the sometimes vexing, often difficult question of how best to construct a system of justice for young people in a way that puts them and any issues that they may be having as young people that may be leading them towards criminal behaviour at the centre of how we respond and how we both view and how we respond to rates of youth offending is by looking at the children and their circumstances and how we can best respond to them. And that is exactly what this legislation seeks to do. The culmination of work that really began in earnest with the tabling of the Armitage and Ogloff report in 2017. From that point, a point where the development of this legislation and this framework began. And it is important to go back and anchor the conversation and anchor the debate in that, because what that report asked for, said that Victoria and Victorian children needed, was a standalone piece of legislation that properly and adequately dealt with the range of issues that confronted youth justice, youth offending in this state. That wasn't part of a different set of arrangements. That establishes, and what this legislation will deliver, is a robust end-to-end framework for Victoria's youth justice system that's all about the children in it. And that's exactly what it should do. It is transformational to the way that youth justice will work in this state, transformational to how we think about youth justice in this state, that will help, yes, keep our community safe, and that is an absolutely and fundamental principle that we should always think about when we think about our justice system. But it will also facilitate us thinking about the children who are in it and what they need. The bill's making some very important alterations to the way the youth justice works, in addition to being a complete end-to-end system in the legislation, separating youth justice elements from the Children, Youth and Families Act of 2005, a standalone framework that allows us to respond to alleged offending by children and young people. It will obviously, and I think very significantly, for those who seek to criticise, very significantly, this legislation is increasing the age of criminal responsibility for children to 12 without exception, and historic change that builds on the change that Labor made in the 1980s, when legislation that a prior Labor government brought before this Parliament, passed this chamber, a chamber that the party of government at the time didn't control, to raise the age of criminal responsibility from 8 to 10. And that Children and Young Persons Act of 1989 was a really important marker, and this Act takes it the necessary step further to bring that age of criminal responsibility to 12. It also, and importantly, and this has been raised elsewhere in the debate, puts into statute the common law presumption of doli incapax for 12 and 13-year-olds, which will add a layer of protection for those children in the system in terms of how they're engaged with in the system. And I'll get to that more in a little bit of detail. Introduce some, facilitate the trials of electronic monitoring alongside enhanced bail and support services and a range of other matters. We know that there are, unfortunately, some rates of offending by young people. We know that causes harm to others in the community. And so when we think about how best to create a framework for youth justice in this state, we need to be cognizant of all of those issues. But what it will absolutely do in terms of the way the legislation is framed, particularly with the codification of the doli incapax principles, which in Chapter 1 of the bill is really a foundational reform, or really a foundational principle. That what that codification does is meaning that a 12 or 13-year-old child can only be found to have criminal capacity if the prosecution can prove, so onus here on the prosecution to prove, beyond reasonable doubt that the child knew that their conduct was seriously wrong in a moral sense, as opposed to being merely naughty or mischievous. And a doctrine that has existed for a long time in the common law, a fundamental common law principle that acknowledges children under the age of 14 often lack the cognitive capacities to inform criminal intent by virtue of their age and relative development. That we know that development occurs in different ways in different children, and so what this principle allows for is for a prosecution in any particular case where we do have offending by children at that age to need to prove that those particular children had the requisite mental and moral appreciation of what they were doing was seriously wrong. That's an important thing to be putting into our statute books, existed in the common law for a very long time, provides that protection for those who are 12 and 13 years old. The other thing I think that's important here, in addition to, as I said, raising the age of criminal responsibility, which this bill will do, and for those who seek to have the age of criminal responsibility raised in this state from 10 to 12, you need to support the bill. That voting for this bill supports raising the age of criminal responsibility here in this state, and to do the opposite means the opposite. And they're some of the stark choices that I think we have to confront, as always, as legislators. I think one of the other really important things that the bill does in Chapter 4 is establish and codify some provisions around diversion and restorative justice. Chapter 4 in the bill establishes a framework for diverting children away from the justice system, and introduces into the statute books this hierarchy of diversionary responses from youth warnings, youth cautions, and early diversion group conferences that will enable children, using the principles of restorative justice, to help repair the damage and restore the relationships that they have harmed by their course of conduct. And these further provisions that we're seeing introduced in this bill enable greater opportunities for restorative justice to be used as a core principle in the youth justice sector. These are really fundamentally important reforms, because at their core is about the children that we are seeing in our youth justice system. That the purpose of the system is not to train them to become better criminals, but to give them the support, the services that they require, the structures, the frameworks, the programs, so that they're not reoffending. So that the system, when they have offended, has legal frameworks and support services around it to ensure that they are supported to not offend again. Because if that's what our goal should be, not seeing offences by anyone in the community, but in this case the youth in our community, we need to put into place provisions that we think and know will ensure that doesn't happen. And there is so much evidence now that restorative justice principles can achieve that, and it's exceptionally important that those are in this bill. I think the other really important thing that the bill does, particularly following one of the reports from the Uruk Commission last year, is embed principles of self-determination inside the new youth justice framework that's being created, and makes explicit in the bill that guiding principles regarding Aboriginal children and young people exist throughout. Puts into law these principles of self-determination that Uruk has told us are important in the way our youth justice system engages with Aboriginal children and young people. For example, giving them the ability and the rights to, whilst in the youth justice system, to support their participation in ongoing cultural activities. Making sure that the system, as it operates, when it operates, does so in a way that reflects the principles of self-determination, heeds the advice on this matter coming out of Uruk. We think that is an exceptionally important element as well. And I think it's important to talk about these aspects of the bill because in the broader debate, often some of these exceptionally important changes, the changes to doli, incapax, the inclusion of the restorative justice principles, the inclusion of self-determination as guiding principles throughout the bill are exceptionally important and shouldn't get lost in the context of other debate. Obviously, the government and the Minister, the Premier and the Attorney-General have made some further remarks, made some further announcements in recent days about the way that amendments are going to be brought forward by the government to this bill to enable a strengthening of some of the bail conditions and some of the bail arrangements that exist with respect to young people in this state, responding to quite clear need. I think it is a demonstration of how serious both the Premier, the Attorney and the government as a whole understands the importance of these issues in the community and is always looking to make sure that our legal framework is best able to deal with the challenges that are confronting it. One of the things that the proposed amendments are going to do is strengthen the bail test to make it crystal clear that bail decision makers must assess both the risk to community safety and the risk of further serious offending when they're deciding bail is appropriate. Make it explicit that if they believe a young person poses an unacceptable risk of committing a Schedule 1 or 2 offence, then that is a clear reason to refuse bail, and will also call out certain crimes that do pose that unacceptable risk. These will obviously be dealt with in far more detail later in the debate, but it is important, I think, to mention them here, and also things like the new Council on Bail Rehabilitation and Accountability, made up by experts who understands what's driving the actions of the offending and reoffending groups in the community. I just want to say that obviously, we are aware that there are members of the community, and I've been speaking to them across the Southern Metropolitan region, who are concerned about rates of offending. I've been speaking to people like the wonderful people at the Neighbourhood Watch down in Bayside, supporting how I can their great work. I've spoken directly with some parents who I won't name here, but who will understand who I'm talking about, who have had a very personal connection to many of the issues that we are dealing with here. I will always be open and willing to talk about difficult matters with the community and use their experiences in this place and elsewhere to help inform the shape of policy. It is exactly what the government should be doing. This reform is so significant for our state. We must support it if we want to see the youth justice system, the justice system for children in this state, be improved.
Thank you, Mr Batchelor. Mrs.